Yes, Mr. Ward.
My lords, my lady, I'm grateful.
And just to be clear, you have a clear run through till 4 now, so...
I'm grateful, my lord, thank you.
Yes.
If I might ask that we start by looking at page 518 in the bundle. This is Copeland and Broomhalf. And it is indeed, as my friend put it to the court earlier, oft cited. But there are elements of it that I should like to drill down on. Particularly about a third away down the page, I think the right claim goes wholly outside any normal idea of an easement. Claim really amounts to a claim to a joint user of the land by the defendant. It is not just possession that should trigger the Ouster Principle. It is joint user. Indeed, in this case, the court says practically the defendant is claiming the whole beneficial user of the strip. Now, that is not the same as occupation. It is not the same as possession. But it's still, even if only obiter would appear to inform the view that that is to trigger the Ouster Principle. It is virtually a claim to possession of the servient tenement, if necessary to the exclusion of the owner, or at any rate a joint user. So it doesn't need to amount to possession or a claim for possession to trigger the principle. It can fall short of that.
Might it not be said that the idea of beneficial user is not a precise legal term, or indeed a term that's known to property law at all?
My lord, yes, absolutely, but I do say that use is a fundamental indicator of proprietorship and ownership.
Right. And that causes me some difficulties as well, for reasons that I've already mentioned. I mean, if you have an easement, you get to use the land.
Yes.
And you can obviously have someone who, in some sense, has ownership, but another person uses their land. So if user is going to be used as the test of the boundary, it doesn't seem a very good test.
Well, my lord, what I say about that is it is to focus. We should focus there on the servient tenement. Is there any residual use left? Because if the use that is being put to the land by the dominant tenement is such as to wholly deprive the proprietor of any use, then it does render ownership illusory. Now, I accept, and I'm going to speak to this in due course, that there is an element of value judgment there. And each of these cases will be fact sensitive. But I say that is not objectionable.
Right. But, I mean, does any easement render ownership? Well, any form of easement type right render ownership illusory. You might have an easement, but the person just doesn't want to use it. And then the owner of the property can do what they like on the property themselves.
They still can't interfere with the ability of the dominant tenement to exercise the easement. So
right, but they wouldn't be if the owner of the dominant tenement happens just not want to use their property right in the form of an easement.
Well, my lord, it would depend on the circumstances, I would suggest. So if there was a right of way over a drive, for example, that somebody is not exercising it, unless and until we start getting into the territory of abandonment, but as a matter of principle, just because somebody is not exercising the right of way and has no interest in exercising the right of way, does not mean, as a matter of law, the servient tenement can build a permanent obstruction upon it.
Right.
Because the easement is a property right, and it's binding on and will benefit successors in title.
But suppose in our case, the owner of the dominant tenement didn't wish, for whatever reason, one summer to store boats on the property. I mean, plainly, I would have thought the owner of the car park could just use those car parking spaces.
Well, my lord, I would have to say not, on the basis that if the right is to place them on there at all times during the period, then anything that is done by the servient tenement that prevents that is an obstruction.
Right, but if they can move the cars off the car park, so it appears that the space is just not being used at all for whatever reason.
Yes.
The owner of the dominant tenant happens not to want to use the supposed easement at that time. And so I would have thought that the owner of the, am I getting this the right way around, the servient tenant, the owner of the car park, could just use it to park cars on that land as they're using the rest of the car park. And then if the owner of the dominant tenement comes back and says, oh, I've changed my mind, in fact, I do want to store some boats here, please can you move your cars? Then they could move the cars. But in the meantime, they'd have the benefit of using the land for car parking. What would be problematic about that?
My lord, what I say about that is that the point about the right is it's in the abstract. So if there is a right to place them there at all times, and in this particular case, not in common with or jointly with the owner of the servient tenement, this is not a first come, first served type argument.
No, but I wasn't putting it as that. So as soon as the owner of the dominant tenement says, oh, I now want to store some boats there, I mean, why isn't that sort of conflict of uses immediately regulated by them saying, and I've got the right, please now move the cars?
As a matter of remedy, my lord, it absolutely is. But as a matter of principle,
all right,
it's not open to the servient tenement to place an obstruction there in the first place.
I see.
It's not a condition precedent. It is not the case that the dominant tenement is obliged to say, please move, and we will then move, and then the right is engaged. It is not in common. There is no priority basis. The fact of the matter is the owner of the dominant tenement would be entitled to say to us in those circumstances, I don't know when I'm going to want to put boats there within this period of time. You must keep it clear at all times. And that would be the effect of the right claim.
Yes, very well, thank you.
I'm grateful. My lords, my ladies, if we might turn then to Ray Ellenborough Park, and in particular pages 9 to 7, and then latterly 939 in the bundle. What I say about this, bearing in mind this follows, chronologically at least, Copeland. The court there, about a third of the way down the page, say the cognate questions involved under this condition are: the rights purported to be given are expressed in terms of too wide and vague a character, whether, if and so far as effective, such rights would amount to rights of joint occupation or would substantially deprive the park owners of proprietorship or legal possession.
So what is meant by proprietorship and legal possession in that sentence?
My Lord, what I say is that there is a distinction drawn by the court, and that is a distinction consistently drawn, and it must therefore be of some significance. I say that possession might be an incident of proprietorship, but proprietorship is not necessarily an incident of possession. It is difficult to say, in the context of granting of easements, that a freehold proprietor is in possession of premises that are let in their entirety on a long lease. Clearly, it is the leaseholder who is in possession. So there is this distinction. They are different concepts.
In the middle of that paragraph, he refers to involve an inconsistency with the possession or proprietorship of the council as lessees. I was wondering whether that should be read as a reference to what constitutes the council as lessees, namely that they have exclusive possession under a lease granted to them. So, I mean, I'm inviting your comments on this. Could that not be read as an inconsistency with the type of possession or proprietorship that the council have as lessees, namely their right to exclusive possession?
Oh, I'm sorry, I'm struggling to find the point that you speak to.
Page 939,
yes.
Middle paragraph.
Is it 927?
Yes, I'm with you.
And he's referred to the example of he's referred to examples which he says it no more excludes proprietorship or possession of the latter than a right-of-way granted through a passage, or than the use by the public of the gardens of Lincoln Inn Fields, to take one of our former examples, amount to joint occupation of that garden with the London County Council, or involve an inconsistency with the possession or proprietorship of the council as lessees. So what I was putting to you is, might it be said that what constitutes the council as lessees is the fact that under a lease they have exclusive possession?
Yes.
And that what's being talked about there is an inconsistency with their right of exclusive possession in that sense?
Yes. Indeed, the finding there being that it doesn't interfere with their possession or their proprietorship as lessees, because as lessees they are proprietors of their leasehold estate, and they are indeed in possession of it.
Yes, thank you.
If I could ask that we look briefly at Batchelor, and at page 423, again we spent a little time on this earlier. There is a quote of an extract of Gale there. I put perhaps a slightly different spin on it, where the editors say, well, an easement involves a diminution of natural rights of ownership. Yes, it does, necessarily so. A grant under which the proprietary rights of the so-called servient owner are either shared or usurped cannot create an easement. So the sharing of the estate, the sharing of proprietorship, or the usurpation of that is to go too far. The line is difficult to draw, and each new case would probably be decided on its own facts in the light of common sense. My lords, my lady, I say, well, that's why a value judgment is not a problem. These cases should be determined on their facts. one would hope that common sense would always feed into such an analysis where there is a value judgment to be made.
But isn't that a recipe for uncertainty and lack of clarity?
My lady, I say it doesn't need to be. That a matter of this nature is fact-sensitive doesn't mean it needs to be entirely without regulation.
Well, you're going to have cases where it's going to depend on the minutiae of whether the pedestrians can walk around the car or whether they've got access by some other means, as in Copeland, to the orchard.
Yes.
Well, surely you're going to have very similar cases that are decided differently according to the minutiae of the facts.
Well, there is, of course, an inherent risk of that, but there's no reason in principle why that can't be constrained in some way.
Well, how? How are you saying it should be constrained?
Well, I have in mind, for example, Thorpe and Frank, in the context of adverse possession. The character of the land can be taken into account. Well, there is a suggestion that at its height, that means we will never know what the outcome is going to be in any adverse possession claim with any kind of certainty, because the individual nature of the land needs to be taken into consideration. But that just isn't how that authority has worked. It's been possible to say, well, open land can be looked at differently to enclosed land, for example. And I say the same is possible here.
But isn't the point being made in Thorpe and Frank that the indicia of when you are someone who's in possession of the land and as a trespasser and asserting a right of ownership over it may depend to an extent on the context in which you're operating in that way, so that if it's open land, it may require different indicia of an assertion of ownership than in other situations.
Exactly so, my lord. But it doesn't.
But then the concept is always clear and constant, namely, is there a sufficient indication of an assertion of ownership by the trespasser? It's just that what is required to satisfy that happens to change according to context.
My lord, yes, absolutely, but it doesn't tell you what the indicia are. And I say that is the effect of what I am proposing.
But might it not be said that the problem of uncertainty to which my lady has called attention goes rather deeper in our sort of case, because we don't know what the concept is that we're trying to identify as being the marker of whether there's an easement or not with any certainty. You do know in Thorpe and Frank what the concept is that's being applied, and it's a question of are the indicia made out in the particular circumstances. But I think that what's being put to you is it might be said that it's more uncertain in our case because by your test or by the test that's been introduced in cases like Bachelor, it's creating uncertainty as to what the concept is that one is looking to identify.
My lord, indeed, and I wholeheartedly agree, other than to say matters such as beneficial use are to be found in the authorities, so the indicia are still covered. What we do, if we accept the test as proposed by Bachelor or close thereto, is to admit the possibility that there is a gap between that which is too eccentric, might it be said, to be an easement, and that which actually grounds possession or a claim for possession.
Could I ask you this, which I wonder whether it might be said is another problem with the reasonable user test? What one person regards as reasonable use may vary from case to case. It might depend upon what their interests are in using the land, what they're hoping to get out of the land. But insofar as we're identifying an easement, that is a property interest that's going to be capable of passing between a whole range of different users.
Yes, ma'am.
And those different users may have completely different interests in how they want to use the land and how important it is for them to use the land in particular ways. So how do you reconcile what might be thought to be the desirability of having certainty across a whole range of people who could be the owner of the easement, all with very different interests in relation to how to use it, and the test of reasonable user, which seems to be typically, when you have a test of reasonableness, is anchored in very specific facts of a specific case.
My Lord, I absolutely accept it would be fact-specific, of course, but I don't say...
But sorry, you say fact-specific, but my question is, which facts?
Well,
so the facts will vary from owner to owner to owner.
Well, my Lord, that's the point. I say that they do not vary from owner to owner. They vary according to the parcel of land with which we're concerned. Reasonableness is an objective test. Bachelor and Marlowe does not say all reasonable uses. It does not prescribe what may or may not be a reasonable use. It simply says reasonable use. That is, for all practical purposes, any use that could meaningfully be said to be made of the land. It needn't have anything to do, indeed it shouldn't have anything to do with the subjective intentions of the parties, because that will necessarily change. And exactly as my Lord says, we're concerned there with successors in title as well.
Yes, thank you.
Hence, when we're concerned, for example, with the viaduct, that clearly admits reasonable use of the land because it is built above it, so something can be done below it, or potentially in the airspace above it, although I think that's perhaps a slightly more complicated proposition. But it doesn't need to be a forensic examination of the facts. It's entirely possible simply because any easement does necessarily involve a diminution of rights. The point is, if all use for all practical purposes has been removed, then it is difficult to say in my submission that there is any kind of meaningful ownership or proprietorship remaining. But if we attach possession to that, as long as somebody is the registered legal owner, and strictly speaking, therefore, is capable of accessing the land, not putting it to use, but accessing it, to the extent they do not interfere with another easement, then the principle would not be triggered. And I say that is illusory. And I say that is no doubt why the authorities that we have looked at and to which I would continue looking stop short of actual possession. Why they are concerned with these principles of user, beneficial user, joint occupation. If I might ask that we turn to page 1001, please, the Thomas Ward Limited and Alexander Bruce Limited matter.
Give me the reference again.
I'm so sorry, the page 1001, my lord.
So what do you say in summary we get from the earlier cases?
My lord, what I say we get from the earlier cases is that there is this distinction between proprietorship and possession. That distinction is informed by reference to beneficial user and joint occupation. And I say that drives a coach and horses through the suggestion that the test should be legal possession. The bottom right-hand side of page
Sorry,
one.
you said it was informed by beneficial user and...
Joint occupation.
And joint
lady.
occupation. Sorry.
Yeah, so you wanted to take us to page 1001?
Yes, please, and towards the bottom of the right-hand column, please. This does not seem to us to be the subject matter of a legal easement, for it involves an almost complete exclusion of the alleged servient owner. That is not about possession, that is about occupation. It is described as seeming a kind of creeping usurpation. I don't rehearse the facts. My learned friend ably did so during his submissions. But what I say about this is the justification for framing the test as one of legal possession overlooks the nuances that emerge from these authorities. And even then, the reference is almost complete. It must.
But I mean, isn't the point being made here that there were two claims being made? One was an easement to scuttle vessels and break them up on the land.
Yes.
But secondly, it was being claimed that there was a right to maintain the silt over the area, in effect, to have the land constituted by the silt that had built up, and to use that themselves. So isn't the point being made here that, in effect, that is a claim to exclusive possession or ownership of the land by the dominant owner?
Well, my Lord,
I mean, it almost looks like a land claim. I mean, it's not to use the property as such, it's to have the benefit of the silt that has been deposited and constitutes new land in the river.
and yet it was brought as a claim for an easement.
Yeah, but they're saying that can't be an easement.
Yes, quite so, my lord. But the point is that the words are almost. And it's about excluding the occupier. It doesn't reference possession or concepts of possession.
It doesn't reference occupation. It's a complete an almost complete exclusion of the servient owner.
Yes, my lady.
Well, isn't that, as my lord has just put to you, exclusion of legal ownership, not of legal possession, rather.
Well,
it's ownership rights that entitle you to exclude others.
yes, it is. Yes.
So that's what it's talking about. It's not talking about some lesser form of occupation.
Well, my lady, that might be right, but on either analysis, it does say that it falls short of that.
What, because of the word almost?
Yes.
Yes, thank you. Well, I think we have your submission.
I'm grateful. Thank you. I do say for completeness that I believe adverse possession was considered as an alternative argument in that case as well, but I don't think we need to go through it.
1002.
If we could then look, please, at Regency Villas, and in particular, page 877. Lost my highlighted paragraph. I'm sorry, if you'll bear with me just a moment.
Take your time.
Thank you. Yes. So around halfway down the first paragraph, so between D and E.
So this is paragraph 58?
Paragraph 58, yes.
Yes.
Discussion of the so-called fourth condition set out by Dr. Cheshire, I believe. Again, I'm skipping slightly further ahead, but the court's been taken through the background of these already. The statement is they include the requirements the right is defined in sufficiently clear terms, not purely precarious, so as not to be taken away, that the right is not so extensive or invasive as to oust the servient owner from the enjoyment or control of the servient tenement. Enjoyment, again, is something that I say is an incident of proprietorship and not necessarily an incident of possession. This reinforces the proposition that the principle is not triggered at that high threshold. It's triggered earlier than that. Well, my lady, if I could ask that we then look at Ward and Kirkland, page 1062 in particular.
Sorry, page reference again.
1062, my lord, please. Now, in this case, we're concerned with the claim to the right to maintain a wall as an easement. And when considering the tests, which in fairness start just at the very bottom of 1061, the court considers whether or not this is a right capable of existing as an easement. And the court's content with the proposition and then needs to consider the objection which is taken to such a right as this constituting an easement is that, so it is said, it would amount to an exclusion of the servient owner from possession of his land. The court then goes on to quote from Copeland. It seems to me approving this reference to beneficial user, or at any rate, joint user. The analysis that we then see on page 1063, where the court grapples with this, in paragraph C in particular, it is quite clear, of course, that the farmyard could be used right up to the cottage wall, but the user could not be such as to destroy the right or any easement to maintain which might exist. In my submission, the court there was persuaded that this claim, this easement as claimed, was capable of existing as such, specifically by reference to the fact that there remained use available to the servient tenement. That, I say, is an entirely proper application of Copeland.
But then, if you read on, isn't the actual test that he applies a bit later? Just between D and D, I for my part.
My Lord, yes, absolutely. And there is that further reference to joint possession. So if the test is limited to one of possession, and that's to be found in the authorities, then possession here must mean something more akin to something that involves either occupation or beneficial use. Otherwise, the concept of joint possession is even harder to understand. If we could please then turn up page 741. I'm going now to Moncrieff and Jameson. And what I say about this is we must be careful not to overstate the criticism in Moncrieff and Jameson. Court derives, the right must be such that a reasonable use thereof by the owner of the dominant land, so the reference to use there is a reference to the dominant land, not residue.
Sorry, where are you reading from?
I'm so sorry, at the top of page 741.
Yes. Is it the bit an essential qualification?
Yes.
Yeah. Okay. Thank you.
Reasonable use thereof by the owner of the dominant land would not be inconsistent with the beneficial ownership of the servient land by the servient owner. The reference there is beneficial ownership. Now, what I say is quite significant about that is the addition of the word beneficial. That necessarily distinguishes from mere possession. A legal owner can be in possession, but not be the beneficial owner. The court continues, two sentences later, to the extent, however, that the Ouster Principle is asserting that a servitude must not be inconsistent with the continued beneficial ownership of the servient land by the servient owner, I would unreservedly accept it. An example is then given. By way of example, if the nature of the purported servitude were to place the dominant owner in such occupation of the servient land as to bar the servient owner from possession or control of it, I would find it difficult to accept that the right could constitute a servitude. my submission, to take the threshold to one of legal possession is to go further than Moncrief invites us to go.
But isn't a grant of the fee simple a grant of the legal estate?
Yes.
So isn't that what he's talking about? As he makes clear in the next sentence. Express grant of such a right.
Yes. Yes, my lady, quite so. Yes.
So it's legal possession. That's what he's talking about.
What he's talking about is that
It's
where...
not just occupation or use, it's legal possession.
Yes, it is, absolutely. But what he says is that is an example of it.
Well, that,
He does not say that's the irreducible minimum. He does not invite us to the conclusion that that's the threshold.
isn't that the test he's proposing?
Well, what I say is the test that he sets out is informed by the suggestion that a servitude must not be inconsistent with the continued beneficial ownership, because that is what he says. So we cannot look at that one sentence in a vacuum. He indicates that as being an example of something because he says, if, for example, the nature of the servitude were, then he would have no hesitation in finding that that would interfere with beneficial ownership. What he does not say is that that is the only point at which beneficial ownership can be interfered with.
I mean, he makes reference to the case of Riley and Booth at page 26, which is page 851 in our bundle.
Yes.
That's the case we looked at this morning where
yes.
Lord Justice Lopez says, the exclusive or unrestricted use of a piece of land, I take it, beyond all question passes the property or ownership in the land.
Yes.
There is no known to law which gives exclusive and unrestricted use of a piece of land. I mean, might it not be said that that cross-reference by Lord Scott tends to emphasise the point that my lady was putting to you, that he's talking about ownership in the sense of the exclusive right to possession, which is the hallmark of freehold, of a freehold interest or a leasehold interest.
My Lord, well, he might be, but nevertheless he refers to beneficial ownership. And by the time of this case, references to joint occupation are well established in the authorities. That can trigger the Ouster Principle.
But what, is there any clue as to what Lord Scott means by beneficial ownership, other than the ownership that you would have as the owner of the fee simple?
There is not, but I say that he doesn't reference the beneficial owner as the owner of the fee simple. His reference to the fee simple is a reference to the grant out of the title, which is, of course, on all fours with Riley.
Yes, thank you.
He also accepts that it might be a licence, not a fee simple. His point is that it cannot be a servitude.
But if it's a licence, then it's not going to be a property interest.
No, indeed.
And where one is concerned with the grant of a property right, which might be an easement or might be the grant of, the example given is a fee simple, isn't the boundary between those two, whether you've got an interest in land falling within Section 1.1 of the Law of Property Act, the marker of which is exclusive possession, or you have an interest in land and so a property right, but falling short of that sense of full ownership.
Yes, absolutely. Yeah.
All right, yes, thank you.
If we could please then move further into Moncrief to page 748.
I'm so sorry I didn't catch that.
Sorry, page 748, please, my lady.
So you've skipped 59, where the test formulated in London and Blenheim is rejected.
Yes.
Yeah, okay. 748.
Well, my lady, I say yes, this is part of paragraph 59. But I want to speak to the test that is then propounded in Moncrief, which appears at the top of 748. It's about the third sentence down. I would, for my part, reject the test that asks whether the servient owner is left with any reasonable use of his land and substitute it for a test which asks whether the servient owner retains possession and, subject to the reasonable exercise of the right in question, control of the servient land.
And that reference to possession must be legal possession, mustn't it?
I think
Occupation and use.
I think that has to be right,
Yeah.
yes. Which is the basis of our objection to the proposition. If possession was considered to extend to some element of use, then our objection would necessarily fall away.
But then he wouldn't have rejected the test.
Yes, quite. The point that I wanted to make was simply the reference to the reasonable exercise of the right in question. The court was very concerned with what amounts to reasonable use. Reasonable exercise of the right in question also presents a lack of certainty.
Well, as I understand it, Mr. Holland was suggesting that legal possession is enough. One just doesn't need control. And so that part of the test falls away.
My lady, yes, I take that point entirely, but nevertheless, the test that was proposed in Moncrief still made reference to the use and the activity by the dominant tenement. I appreciate the appellant contends for a slightly different test.
Yes.
Looking at the last sentence of paragraph 59, it might be said that Lord Scott, when he talks about control, he's saying that it's subject to the reasonable exercise of the right in question. It's like the other side of the coin. If you've got an easement, you're only entitled to make reasonable use of your easement right. You can't make unreasonable use of it. And Lord Scott seems to be talking about the control as being, well, that's what's left over after you've allowed for restrictions, in fact, on the right in question, that the use of it has to be reasonable.
Yes, so as not to create a nuisance, of course.
But, I mean, if one reads it in that way, doesn't that, again, it might be said, push one, at least understanding what Lord Scott was saying, to the idea that he was talking about ownership in the sense of does the servient owner still retain exclusive possession, which is the marker of ownership of land by a freeholder or a leaseholder?
Possibly so, my lord, and it would certainly be consistent with the test that he invites as a substitution. But nevertheless, he's chosen his words differently. His reference is still to beneficial ownership, and then latterly to possession and control.
Yes, thank you.
And if that is right, then control would need to form part of the test as well as possession. The test otherwise doesn't meet his lordship's objections or the mischief that he seeks to cure, because surely both are incidents of ownership.
Yes, thank you.
Thank you, my lord.
Did you want to show us anything else in Moncrief?
I do not, my lord, thank you. And candidly, my lords, my lady, on the first ground, I don't have very much more to say that I haven't said in our statement of case or said to you today.
Yes.
I don't know if there is any point in our statement of case where you require me to make good or explain myself.
Well, could I just ask you about paragraph 76 in Moncrief? This is Lord Rogers' speech.
Yes, of course.
Where he talks about forms of servitude involving, to some extent, complete exclusion, physical exclusion of the servient owner.
Yes.
But he says, putting it crudely, that's fine. That can still be an easement, even though you've got complete exclusion in a physical sense in that way.
Yes, my lord. My lord, what I would say about that is the beginning of that paragraph is instructive. Of course, servitude of parking would involve a car being placed on the neighbour's land, and this would prevent the neighbour using that part of his land when the car was stationed there. But that cannot in itself be a conclusive objection to the existence of such a servitude. It is part of the land.
But in such a case, all that the servient owner retains is the sort of residue of their ownership right, which is, in English law terms, the right to exclusive occupation, out of which various rights have been carved.
Yes, my lord. And in respect of the residue of their land.
So I mean, my question really is paragraph 76 not against you? You were saying one shouldn't read the comments in Moncrief as actually supporting the appellant's case in this appeal, but does not paragraph 76 support it?
My Lord, I say no, because it's a reference to part of the land. It's not a reference to the entirety of the tenement. So it accepts that there can be no use made of part of a tenement when the dominant tenement is making its own use of it. That is not the same as a servient owner can be completely excluded from any use of their land.
Yes, thank you.
Thank you. Before we leave ground one, if I might ask that we look briefly at Miller and Emser at page 718, please.
Yes.
At the top of this page, the court is content to find that there were all the characteristics of an easement present. There is no doubt as to what were intended to be the dominant and servient tenements respectively. The right was appertenant to the former, calculated to enhance its beneficial use and enjoyment. It is true that during the times when the dominant owner exercised the right, the owner of the servient tenement would be excluded. But this, in greater or less degree, is a common feature of many easements, for example, rights of way, and does not amount to such an ouster of the servient owner's rights as was held by Mr. Justice Upjohn to be incompatible with a legal easement in Copeland and Greenhalgh. Question of fact and degree, in my submission, is supported by this case.
What, a test based on a question of fact and degree, did you say?
Yes, so that the reasonable use test, such as to render, or such as not to render, ownership illusory, is a question of fact and degree. And I say more that than value judgment.
Trouble is, there isn't really a frame of reference, is there, for that test? I mean, it's all very well saying it's a question of fact and degree, but that doesn't really help you unless there's a frame of reference. What's the frame of reference for this reasonable user? I mean, is it what sort of person are you talking about, and what sort of use
Well,
does the court assume? I mean, I struggle to understand the question without some parameters around it.
Well, my lord, I say the reference is to the land, not what any given individual might want to put the land to. The question is whether or not some use could be made of the land. because if it cannot, if its use has become, if any
Do you mean the
use,
surface of the land, or do you mean the surface of the land? Do you mean the bit? Do you mean the ground under the surface, or do you mean the air over the surface?
within reason, any of the above, my lord.
Pardon?
Within reason, any of the above, my lord, because they all form part of the land. They all form part of the title. So it is right to say that it might be the case that pipes could be run under land, and that would be a reasonable use, because it's possible. It matters not whether or not anybody is likely to run them. The question is the nature of the land such that that would be a reasonable use of it?
Yes.
I'm grateful. I turn then to ground 2,
Yes.
Lords, my lady. And what I say is this: even if the appellant is right,
Sorry, even if the appellant is right about what?
about the position on ground 2, the reasonable use reference, sorry, forgive me.
So we're for ground 2, we're changing
Yes.
the sort of predicate
Forgive
for
me,
the argument, aren't we? That-
yes, indeed. I mean, even if the respondent is right, we
Yes.
say we should still succeed.
So even if the respondent is right as to the test,
Yes.
being one
Yes, exactly so.
of reasonableness,
Yes.
the appellants say we should still succeed, and now you're going to tell us why.
Why? Quite so. Thank you. We say it's entirely right that the reference period is the period of time during which the area is in use. This can be distinguished from the likes of Miller and Emser, perhaps even Copeland to that end. We're not concerned with intermittent use for a day, for a number of hours.
Why not? We're concerned with certain months of the year.
Yes.
Why isn't that intermittent?
It's intermittent insofar as there is a block of months where no use is made at all, but for an uninterrupted period of several months, there is, for all practical purposes, exclusive use being made.
Well, not exclusive use.
Well, we say we are left without any reasonable use during that time.
But what makes you say it's not intermittent just because it's a block of time?
We say it's not intermittent because it is for an extended period of time, and that is what the right is claimed for. So the right is not claimed over the period of 12 months. The right is claimed to use that land to the
Each
point.
year
Each
over
year.
this period?
Yes, exactly so.
Intermittently between summer and...
Well, my lady, I say intermittently, it involves something rather more akin to questions of continuity of use. So we're not concerned with fixed hours during the day where there is any residual use.
No, it's fixed months per year.
Yes, which I say is substantial, and I say on that basis it is to be
So what is it that's the distinguishing factor, that it's a block of time?
Yes, exactly so. An extended block of time. It seems to me the quality of use in these particular circumstances, where it is 24 hours a day, 7 days a week for 6 or 7 months of the year, is very different to the quality of use if we were talking about certain hours of the day.
But if the test is one of reasonableness or retention by the servient owner of the opportunity reasonably to use their land, why shouldn't the reasonableness test not be capable of accommodating a degree of intermittency? I mean, suppose that the servient owner has made it clear that they just have no use for their land for 1 month a year, and the purported easement is in relation to that 1 month when the servient owner just doesn't wish to make use of the land. Why couldn't one take account of that in assessing whether there is a sufficient retention of reasonable use of the land by the servient owner? I mean, almost ex hypothesi, there would be sufficient reservation of reasonable use by the servient owner on the particular facts.
There might be on the particular facts. They are not the particular facts here. We are here concerned with a much more extended period than that.
Right, but all right. But that seems to be an answer that seemed to concede the point of principle that you could take account of the intermittency of the use by the easement owner.
I don't...
in assessing whether there was still reserved to the servient owner the opportunity reasonably to enjoy their property.
I see my Lord's proposition being that we are left with reasonable use on the basis that we are left with 11 months of the year in which to use it. No, I disagree with that proposition. I say that the assessment should be the period of time in which the right is being exercised. So if for that 1 month...
But I appreciate that you're saying that you disagree with the proposition, but I'm just trying to test it. If we're now operating with a notion of is there sufficient reasonable use left available to the servient owner, why should one exclude consideration of the intermittency of the use? Well, I mean, in a sense, wouldn't it be like the sort of time equivalent of what you get with the car parking cases? Yeah, I've forgotten the name of it. Well, I think it was London and Blenheim itself that Sir Paul Baker, Judge Paul Baker, seemed to suggest that, well, as long as you had a car park with, let's say, 20 spaces and people could just use random spaces, but they could use spaces, that's okay in terms of granting an easement, even though it might not be possible to grant an easement for just one parking spot. Well, that's a spatial equivalent where there's a sort of some occupation, but it doesn't blank out the whole of the use for the servient owner. Why couldn't it be said, when one looks at it in time terms, that to some extent it's the same problem, that the servient, the easement owner is going to be occupying the land for part of the time, but for the rest of the time it's available for use by the servient owner?
Well, my Lord, I say in answer to that because if the occupation is so substantial that there is not going to be any residual use, then the time during which there is no occupation is irrelevant. Because for that period of time, what we see is something far more akin to a license, a lease, some kind of exclusion, some kind of exclusivity. So it matters not that there is other time available. That is of a different character and different nature, I say, to using a parking space for 8 hours a day, for example.
Yes, thank you.
Even if I am wrong about that, for an extended period of time, for blocks of several uninterrupted months, For all practical purposes, the respondent cannot do anything with the land.
But for extended periods, the respondent can, October to May.
Yes.
So, I mean, that's just the same point. Or are you making a different point?
No, I'm making a different point, my lady.
So what is the different point?
The different point is that the impact on us when the right is being exercised is so substantial as to not leave us with reasonable use.
But you've got reasonable use in the other substantial block, equally substantial block of time.
Yes, we have.
So I don't understand the different point that you're making.
Because we should be able to, this is the nature of the use that the dominant tenement puts us to. And the nature of the use that the dominant tenement puts the servient tenement to is such that while it is being exercised, there is no reasonable use. And that, taken as a whole, is not reasonable. It's not a temporal point.
I think I'm right in saying, but correct me if I'm wrong, that the first tier tribunal and the upper tribunal took the law to be that if there was exclusion of reasonable use by the servient owner for any period of time, it couldn't be an easement. So if the true view is that, in fact, the question of intermittency is a matter of fact and degree, just as the question of how much space is being used up is a matter of fact and degree, would you accept that both the first tier tribunal and the upper tribunal had applied the wrong test?
I think I would have to.
Yes. So can I just ask you, if that were the view that we came to, would the conclusion be that we would have to allow the appeal but remit the case to the first tier tribunal to make an assessment on the proper basis?
Yes.
Right. Okay, thank you. So I think you've dealt with the first of the
Yes.
grounds or sub-grounds that arise under ground 2. Was there anything more you wanted to say about that first one, or do you want to move on to
Not about the first one, my lord, no.
Okay.
I'm grateful, thank you. In some respects, my lord, the answer to the second point, or indeed the only additional answer I need to give you to the second point, is very similar to where we get to on the first point, which is, well, if some other evidence should have been taken into account, then it needs to be considered, if that is something that should have been contemplated. What I in fact say is, well, the tribunal wasn't shown evidence of utilities running under the land, it wasn't put in issue, and therefore it was entitled to reach the decision that it reached.
Sorry, I missed that. Did you say alternative uses weren't in evidence, did you say?
Yes, exactly so, yes. I say there's...
But I mean, sorry, just going back to an answer you gave me a little while ago, when I asked about the fact that different owners might have different uses they want to get out of their land, and I was putting it to you, well, isn't that problematic in terms of your submissions on ground 1? You said no, because the courts would have to adopt an objective approach, so you'd somehow have to identify some sort of objective
Yes.
owner, and what use would they reasonably wish to make.
Yes.
If we're looking at subground B of ground 2, if it's an objective test, might it not be said that the first tier tribunal and upper tribunal have gone wrong in looking at what is in fact happening on the ground? Shouldn't they have been asking an objective test and not taking into account evidence of what's happening on the ground, because that's just reflecting the particular interest of this particular owner at a particular point in time?
My lord, it might be, but the point is that no evidence was given on the subject, and it would surely have been for the applicant to demonstrate that these were the alternative uses to which objectively the land could have been put.
But this is about potential use, not actual use.
Yes.
I mean, is that an evidential matter, or is that a matter of common sense and submissions?
It might be so, my lady, but it seems that it wasn't particularised, it wasn't put.
Can you just help us? What did the first tier tribunal and the upper tribunal say about potential alternative uses and the absence of present evidence?
Starting with the first tier tribunal, my lord.
I'm sorry, Mr. Cohen did give us references, but he was, for understandable reasons, having to go at
Having to trot through, yes, quite so.
Speed.
I think
My lords, we can put those, we can put those in writing.
Well, it would be helpful just to have our attention directed to it now, since we're debating this particular issue.
I think there was a discussion about resurfacing and replacing the lines at paragraph 11 in the FTT. Use in the summer months at paragraph 44.
Yeah.
Gig storage at paragraph 16.
Yes.
And then 60, 61 and 65. Those are just, I haven't noted what they were there.
No.
Oh, 60 is using in summer months, 61 is painting lines over and resurfacing.
Yes, of course, that is on the basis that that is a period when it is not in use.
Well, at all events, can you help us? I mean, as I understand, you're defending the decision of the first tier tribunal and the upper tribunal.
Yes.
Against the charge laid against them.
Yes.
In subparagraph B, or subground B. Where did the first tier tribunal and the upper tribunal address the issue of
Alternative use.
yes?
Yes. My lady is quite correct to identify paragraph 60, which starts at page 121.
This is paragraph 60 in the first tier tribunal.
Yes, it is.
Yes, thank you.
But that does seem to be framed more in the context of the temporal test. So too in paragraph 61 and 62. Paragraph 61 indicates that counsel for the appellant in the first tier tribunal contended that there are other uses that the area can be put to during October through to May. Such as painting lines over or resurfacing the storage area. The court found there, with 6 boats, perhaps even fewer, it would not be possible to paint or resurface, and that would have to wait until the boats were removed. If your lordships and ladyship would give me a moment, I'll just review the upper tribunal decision. Thank you. My Lords, my Lady, I'm grateful to my learned friend for the indication, page 84.
This
the
is
upper
in
tribunal decision.
the upper tribunal,
Yes.
page 84. Yes, thank you.
And paragraph 88. Yes. Sorry, I understand. Yes, I'd actually, I think paragraph 88 might be helpful nevertheless. So we see reference to the description of the triangle area in paragraph 88.
Yes.
And that paragraph says it's obvious that once 6 boats are stored on the triangle, there is no room for any other activity to be carried on within the triangle. If we then turn through to page 88, paragraph 108, the point is specifically addressed.
I'm sorry, which, can you give me that reference again?
Yes, of course, page 88, paragraph 108.
Thank you.
In considering whether any reasonable use of the relevant servient land is left to the owner of that land, it's necessary to concentrate on the servient land. One doesn't treat the servient land as including other adjacent land, but I don't think that assists the appellant. Then at paragraph 109.
Isn't that an error? Why is the fact that they could walk round or a different way, why does that mean you can't take into account as part of reasonable user that remained the fact that they could walk between the boats just as pedestrians can walk between parked cars?
Forgive me, I don't quite follow the point. I think they
The
did
judge
consider
discounted, both in the FTT and in the upper tribunal, the possibility of pedestrian access on the basis that it had no utility.
Yes.
Yes, isn't that an error?
My lady, I say it is not an error. It was still considered, and it was considered to be not sufficient to amount to a reasonable use because there was no utility. So it wasn't an indication of a reasonable use.
Yes.
And that's qualified further by the upper tribunal at paragraph 110 and 111. And further down, page 89 at paragraph 118, there is further consideration.
Yes, thank you. So was there anything else you wanted to say about ground 2B?
My Lord, I should simply make the point that the points are made from paragraph 112 onwards in terms of the use. And they're taken in turn. In the context of ground 2C, I don't have anything further to say that I haven't said in my written statement.
Could I ask you then about your paragraph 80 on page 62?
Yes.
Where you say, even if the test should be as the appellant contends,
Yes.
there's no meaningful way in which it can be said that the respondent retains exclusive possession or control. Is it your submission that this would have to be remitted if we were to accept the appellant's argument that there should be a different test applied? Would it have to go back?
My Lord, I think I have to say yes in answer to that, because if it is a different test that should be applied, it is because Batchelor and Marlowe effectively has been set aside or departed from, and it is only right that the respondent should be able to answer a different test.
But if the test is exclusive possession, legal possession, whichever word you want to use,
Yes.
you can't possibly say that your client's exclusive possession and that the grant has had the result that they have been deprived of their exclusive possession. Can you?
Well, my lady, it would depend, I would suggest, on whether or not this court was with me on the temporal point. It still seems to me that the respondent needs to have an opportunity to answer that case properly and to plead
Even if
its
it's
case.
about legal possession?
Even if it is about legal possession, yes.
I'm afraid I didn't quite follow that. Even if we were with you on the temporal point,
Yes.
if the test, going back to ground 1, is legal possession in the sense of exclusive possession as the marker of a freehold interest or a leasehold interest, I would have thought that it's clear on any view of the facts that the dominant owner does not have exclusive possession of the triangle of land in that sense. So if the test of whether there can be an easement is whether what has been done is to grant exclusive possession of the relevant piece of land, and it's that excludes an easement from arising, I wouldn't have thought that you could say that the dominant owners have been granted exclusive possession of the triangle of land in that sense.
Even by reference to the period when they are
Yes.
using it?
Yes, even by reference to the period when they're using it.
Okay.
That's presumably what you are saying in paragraph 80.
Exactly so.
That you're saying quite, well, that isn't the case.
Yes.
There's no way in which you could say that the servient owner has been given exclusive possession, as I
It's
understand.
been left with exclusive possession.
Dominant.
That's quite right. We would want to argue that there was joint possession or joint occupation. And it seems to me that would need to be particularised and evidenced.
All right, thank you.
My Lords, my Lady, unless I can assist you further there.
Can I just take you
Yes,
back,
of course.
sorry, to this, something that's just bugging me about this, about the question of continuity and the period of time over which you assess reasonable user on the hypothesis we were looking at before.
Yes.
And if you go to page 86 and the upper tribunal, paragraph 99.
Yes.
I mean, what's said there is that the disputed easement was claimed as an intermittent easement, that is to say an easement which was not continuous, but which only had effect in a certain part of each year. Can I just try and understand how this works? In order to get an easement by prescription, you need a 20-year continuous period.
Yes.
And as I understand it, it's not said that there are a series of easements that arise every year. In other words, as I understand it, there's one easement.
Yes.
Which is only said to give rise to a right to use the triangle for a period.
Yes.
But there's only one easement because that's what there had to be, because
yes.
you had to have 20 years continuous use to get it.
Yes.
Well, if that's right, why do you confine your examination of reasonable user to just the period of use as opposed to the totality of the period covered by the easement, alleged easement, which, as my Lady Simler said, is the time when the boats aren't there as well as the time that they are?
Well, my Lord, we run the argument in the first place that there was interruption and it wasn't continuous and therefore wouldn't amount to an easement in any event. But that notwithstanding...
You lost on that argument and there's no appeal.
Quite so, yes.
Yeah.
Yes.
So it's one easement, as my Lord has put to you.
Oh, no, quite so, my lady. Yes, absolutely.
But isn't that this sort of slight error of thinking in paragraph 99 that it's confusing two things? It's being dragged into thinking that it's an intermittent easement in the sense that it's an easement which only lasts for the winter months.
Yes.
And then it stops.
Yes.
And then you get another easement, and then another easement every year.
Which cannot be the case. Yes.
And
yes.
so if it's a continuous, it's just one easement. You've got to look at the totality, the user over the totality of the period.
My Lord, we say no, and we prefer the view of the upper tribunal. And the view there was, if it's temporally...
I'm trying to just push you to tell me why.
Yeah, yes, no, quite so. But we say what we are looking at is the exercise of the easement. The easement is only claimed for fixed periods, and therefore the question is, what is the nature of the user, what reasonable user remains during the course of its exercise? And the particular character of this easement is such that you need to focus on the block of time. It is different in nature to something that is done on a daily basis or for a few days at a time or what have you, where there is a significant period of time, a significant block of time, as is the case here. The reference point has got to be the time when it's in use.
Okay, so when the upper tribunal said just two-thirds of the way down paragraph 99, the appellant's argument involves assessing the extent of the use of the servient land pursuant to the relevant right by reference to a time when the right does not apply. It seems to me that do you not have to assess the use of the land by reference to the time at which the easement exists, the easement being one continuous easement?
I think, my Lord, the point there is that the existence of the easement is separate from its exercise. So that the easement exists at all material times, if it exists at all material times, does not change the fact that when we're considering whether or not there is any residual reasonable user left, the reference point is when it is being exercised. In circumstances where it is not just for a few hours at a time, but is in fact continuous for extended periods of time.
Yeah, but and then just again, and I'll just the final point. But it's the sentence above. And it seems to me that the adoption of this approach involves treating the servient land as if it was subject to the relevant easement at a time, and because of the temporal nature of the easement, it's not in fact subject to the relevant easement. I mean, it is in fact subject to the relevant easement. It's just
As a matter of law, it would always be subject to it, but it would not be being subjected to its exercise because of the nature of the easement and the right claimed.
Okay.
I don't think I can take that any further than that, my lord.
Thanks.
Yes. I don't think there are any other questions. Thank you very much. Now, although there isn't a right of reply, just in case there's anything that might be said, Mr. Holland, by you that could assist us, I think that the court would be willing to listen to you for 5 minutes if there's any particular point that you feel.
I have 5 copies of the relevant.
Sorry.
No.
Yeah. Yes. So one matter that would be helpful to have your submissions on is disposal, depending on various outcomes. So you heard us debate with Mr. Ward what would be the outcome if you're right in your submissions, and indeed what would be the outcome on ground one, or if you're right on your submissions on any part of ground two. So it would be helpful for us to have confirmation as to what you say should happen on any of those things. But if there's anything that you feel that we would be assisted by having short submissions from you in reply, I think that we're happy to indulge you to that extent.
I'm very grateful. I've just done it. I've got 5 copies of the article.
Oh yes, thank you. Well, perhaps we could ask for that to be handed out now. It would be useful to have that.
So far as disposal is concerned, well, if we win on ground one, that is, the test is as we propose, we would submit, we agree with the reaction, I can't say it's the view of the court of my Lord Sales, that it cannot possibly be said. It's a matter of law, and it doesn't need any further investigation of the facts to decide that the test is wrongly applied, and on the facts of this case, you're in as good a position to judge as the first tier tribunal.
Right, so if you win on ground one, no remittal, we just decide the case.
Secondly, but then look at ground two. If, for example, we win on the application of the test, for example, and they were wrong to take into account the fact that as this is an intermittent easement, you discount the periods during which the easement is not exercisable, albeit exists as to that bit. If that's right, then there are clearly periods of 4 months during the summer when which you take into account in deciding whether there's reasonable use or not. And it's difficult to see how remission is required to decide that there's a reasonable use retained by the survey donor. There's a significant use because the cars can be parked on the land, and indeed are parked on the land in the summer months. And
well, might it not be said that we're actually not fully equipped necessarily with all the facts that might bear upon the reasonableness?
It's difficult to know what sort of facts. I mean, you've got the witness statements and you've got the findings of fact. I mean, the evidence was that the car park is used during the summer months.
As just part of the rest of the car park?
Part of the rest of the car park.
In the same way as the rest of the car park is used?
That's right, and it's been used to store gigs, it's been used to reverse, and it's difficult to see what possible or proportional justification there could be for putting us all back to the first tier tribunal to decide there's absolutely no need. And
right.
Similar applies with the other. I mean, you've got the relevant paragraphs of the upper tier tribunals, 89, 109 and 112 to 118. I think you've got those eventually. And if one's dealing with theoretical uses, well, again, they are theoretical uses. We're right in saying theoretical uses. Then you know what the land is, and a theoretical use is not said. It's right, there's no evidence that the council wanted to put utilities over or under the land. But that is a theoretical use. There's no evidence that that wasn't possible should they have wanted to do that.
Right, so you say the proper approach, is this right, to reasonable user is it's an objective test. This court has sufficient information to be able to apply that test itself,
yes.
And so do not remit. That's your submission.
Yes.
Yes.
Excuse me. Yes. And my friend Mr. Cohn points out, and he's right, as my learned friend concedes in his written case, the bar is a fairly low one as to reasonable use.
Sorry, which part of the respondent's case are you referring to?
I'll dig that out. Can I know it says it, so...
All right.
Yes, paragraph 40. The test is expressed as any reasonable use. This is a low threshold to meet. Paragraph 40, page 56. By way of response, I have very few comments. Just, my learned friend took you to various parts of the previous authorities. I had cited the previous authorities to you for 3 reasons. Oh, one, I'd made 3. One, you're not bound by any of them. Secondly, they don't support the current test in Batchelor and Marlowe. And thirdly, insofar as you can divine a coherent thread through what the judges are saying in those cases, and it may be difficult to do so, they are more in line with what we say the test is than what the learned friend says the test is, as in Batchelor and Marlowe, albeit I accept there's not, it's difficult, there's no unanimity of terminology or necessarily coherence of terminology. Lord Sales was right in dealing with the test of adverse possession when my friend took you to Pye and Graham. One of the part of the test for adverse possession is factual possession. The test of that is paragraph 41 of Pye and Graham at 824, and it depends crucially on the nature of the land you're dealing with. That is part and parcel of the test for adverse possession. So far as non-user of the dominant tenement is concerned, and my Lord Sales had a discussion with learned friend about that, the right of a person who has an easement over land is not to have that right substantially, the exercise of that right substantially interfered with. His claim, if the right is interfered with, is a nuisance, and there has to be substantial interference with the exercise of the right. So suppose my client doesn't put boats on the triangle one winter, the council would not be substantially interfering with that right if they used it to park cars when my client's boats weren't there, or drove cars over it when my client's boats weren't there. Because my right, the exercise of my client's rights wouldn't be substantially interfered with. If he then came along midway through the winter and said, I want to store some boats here, please get your cars off, he would be perfectly entitled to do that. But it's not a breach, it's not a substantial interference with my client's rights for cars to be parked there if and so far as he's not exercising his easement. Finally, you were taken to, I think, paragraph 58 of Lord Scott's judgment in speech in Moncrieff and Jemison, which is at 745. Sorry. And it was talking about the reasonable exercise of the right, I think was the phrase that the learned friend focused upon at, so it's paragraph 58, sorry. Sorry,
59.
59, great. That's right, 59. And I think Lord Sales got the point, and that's a reference to the exercise of the right by the dominant owner. It's a reference back to what Lord Scott and the Scottish judges called the Ouster Principle, which you will see at paragraph 45 in Lord Scott's judgment and paragraph 95 in, it's not Lord Hope, it's Lord Roger's judgment. It's the principle that if you have an easement, you have to exercise its civiliter. And so it's nothing to do with the reasonableness of any use which the servant owner might retain. It's a completely different point.
So if we were with you on ground one,
Yes.
are there implications of taking that course that we should be aware of? I mean, Lord Neuberger seems to have had some disquiet.
He does, and I'm afraid I don't see it. I've tried to understand what he is concerned about, and it's why I went into perhaps a little too much detail of the difference between, if you get a written, I mean, I think his concern is expressed, I think it's what, 100 and...
It's 144, page 769.
That's right. Right to park a vehicle in one vehicle space can be an easement. It may be hard to justify an effectively exclusive right to store any material not being an easement. Well, I say it is, which could be said to be the logical conclusion that occupational licence should constitute an interest in land. I'm afraid, having thought about that repeatedly, I don't really understand his concern there. Whether or not something is an interest in land or a licence, again, depends upon the construction of the agreement. If you're dealing with a written agreement, as I said at too great length, one needs to construe it, look at what the rights are granted, and then categorise it. And it may be difficult to do, but there are clear, bright lines between a conveyance, grant of a lease, the grant of an easement, and the grant of a licence. So I don't accept that that's a justified fear, albeit it may be that given the arguments in that case, Lord Neuberger wasn't prepared to go as far as Lord Scott. I think that's clear to say. But I just don't see it. I haven't... I couldn't really... And I hate to disagree or stand back from Lord Neuberger, but I don't see that there's that fear which he has, or that there's any particular concern.
Because the courts, in relation to paragraph 144,
yes,
the courts would just then have to make the usual characterisation as between a proprietary interest and a licence.
Yes, that's right. If you're dealing with, I mean, there's I think there's three ways in which an easement can arise. There's express grant, and that's a matter of contractual construction as to what it writes and how you write it. There's prescription, which is you have to look at the evidence, and again, whether that... I don't see how you can then risk categorising an occupational licence as an easement. Or there's by implication under section 62, and again, you do have to look at the behaviour immediately prior to, the evidence of the behaviour immediately prior to the relevant conveyance. But again, I don't see, and that can turn precarious rights or precarious arrangements into rights, but that's the effect of section 62.
Can I just check? Yes, so the Law Commission report comes after Moncrief.
Yes, it does.
Yeah.
Cites Moncrief.
Good. Is there anything else that you feel we should draw our attention to?
No, my lord.
Very well. Well, we're very grateful to the parties for their oral submissions and their written submissions. We're grateful to everyone who's been involved in the production of the written submissions. This is a case which has left us with a great deal to think about, so we will reserve our judgment and deliver it as soon as we are able. This hearing is now adjourned. Thank you.